Her husband spent 41 years making sure she would be okay. He paid off the house. He wrote a will. He named her in every conversation about what should happen when he was gone. She knew where the safe was. She knew the account numbers. She thought she knew everything. He passed away on a Tuesday morning in March. By Thursday, she had discovered that the largest account in the house, the one with nearly $90,000, was set to transfer automatically to a woman her husband had not spoken to in over 2 decades. Not because of fraud, not because of anyone's intention, because of a form he had filled out in 1987 and never updated. The will said one thing, the form said another. The bank followed the form. If you are over 65, or if you are helping a parent or spouse manage their financial life, what I am about to share with you is not about changing your will. It is about understanding that a will is only one document in a system. And in that system, there are 5 other forms that can quietly take priority. Not because of a loophole, not because someone is trying to take advantage of you, but because that is how the law is structured. The form wins. Stay with me, because the 5th one is the form most families never check until it is too late. Let me be clear about what this video is and what it is not. This is not a video telling you that your will is worthless. A will is an important document, and if you do not have one, that is a serious conversation worth having with an estate attorney in your state. What this video is about is the space that exists between what a will says and what actually happens. Because for most seniors over 65, that space is larger than they realize. And inside that space are 5 forms. Not laws, not court orders, not anything requiring a lawyer to find, just forms. Forms that were likely signed at some point in your life, possibly decades ago, possibly in a 5-minute meeting at a bank desk or a new job orientation, while your attention was somewhere else entirely. These forms are not hidden. They are sitting in files at your bank, your brokerage, your insurance company, and in some cases at your county recorder's office. But because no one sends you a reminder to update them, and because they do not expire the way a car registration does, they can go years, or in some cases decades, without being reviewed. What I want to do today is walk you through each one. Not to send you into a panic, not to tell you that everything is broken, but to give you enough understanding that you know which questions to ask, which files to pull, and which conversations to have. Ideally before your family needs to have them for you. This applies whether you are married or widowed, whether you own your home outright or still carry a mortgage, whether you have a large estate or a modest savings account. At least 3 of these 5 forms very likely apply to your situation right now. And here's the thing to hold on to as we go through this. In almost every case, checking one of these forms costs you nothing. It takes a phone call, maybe a trip to your bank, maybe 20 minutes with a document you already own. The cost of not checking it can be something else entirely. Let us start with the one most people believe they already understand. The story I opened with, the widow, the $90,000, the name from 1987, that is not a rare story. It happens in some variation regularly across this country, and it almost always involves a beneficiary designation form. A beneficiary designation is the form you fill out when you open a retirement account, an IRA, a 401k, a pension plan, or a life insurance policy. It asks a simple question. Who should receive this money when you die? You write a name, you sign the form, you hand it back to the representative, and you move on with your life. The problem is that most people fill out that form once and never look at it again. Think about the events that can happen in 20 or 30 years. A divorce, a remarriage, the death of the person you originally named, a child born after the account was opened, a falling out with a family member, a relationship that changed in ways you could not have predicted. Each of those events may have changed who you would want to receive that money. But unless you physically updated the form at the financial institution, the original name is still there. Here is the critical thing to understand. A beneficiary designation is not controlled by your will. The law in most states treats these designations as contracts, direct agreements between you and the financial institution. When you die, the money goes to whoever is named on that form, regardless of what your will says. A will cannot override it. A family member cannot contest it simply because they feel the situation is unfair. The institution follows the form. This is not a loophole. This is the intended function of the designation. It was designed to move money quickly and directly, bypassing probate. The problem is that the form was designed for a snapshot of your life, and life does not hold still. To check yours, you do not need an attorney for this step. Call your bank, your brokerage, your insurance company, or your HR department if you have a pension. Ask them, what beneficiary designation do you have on file for my account? They are required to tell you. Write down the name. Then ask yourself honestly, is that still who I want? One additional detail that trips up a lot of families. Many accounts allow you to name not just a primary beneficiary, but also a contingent beneficiary, a backup. The contingent beneficiary receives the money if the primary beneficiary has already passed away. If you have not named one, and your primary beneficiary is no longer living, the money may flow into your estate instead of transferring directly. That can pull the money into a probate process you were trying to avoid in the first place. One form, one name. It can redirect a retirement account, a life insurance policy, or a pension to someone you have not spoken to in decades, or leave it in legal limbo for months. Check it. We are going to come back to the widow's story a little later, because what she found in the second form made the first one look simple. While a beneficiary designation controls retirement accounts and life insurance, the account title controls something different. Your regular bank accounts, your checking and savings, your joint accounts, and in many cases, your standard brokerage accounts. The title of an account is the legal description of who owns it and what happens to it when one owner dies. Most married couples have joint accounts, and most joint accounts include something called the right of survivorship. That phrase means exactly what it sounds like. The surviving spouse inherits the account automatically when the other dies. No probate, no delay. You bring in a death certificate and the bank transfers the account. That part usually works the way people expect, but here is where the complications begin. Not all joint accounts include the right of survivorship. Some are held in what is called tenancy in common, where each person owns a share, and that share, when they die, goes to their estate, not automatically to the other joint owner. Two people can be sharing an account, using it every day, and one of them may not realize that their half of that account will go through probate when they are gone. Most people do not know which type of title their account has. They opened a joint account, they share it comfortably, and they assume it will pass automatically. That assumption is worth verifying. There is also a type of designation you can add to most standard accounts called payable on death, sometimes written as POD, or transfer on death, sometimes written as TOD. These are instructions added directly to the account that function like a beneficiary designation. They tell the bank who should receive the money when you die, outside of the probate process. Many bank accounts do not have these unless you specifically requested them. If your account has no POD or TOD designation and is not jointly titled with survivorship rights, it may require a probate proceeding before your family can access it. For widows and widowers in particular, this deserves close attention. When a spouse dies, the surviving spouse often changes or consolidates accounts, which is completely understandable. But if a new account is opened during that transition, without attention to how it is titled, and without a payable on death designation, that account may not transfer the way the survivor intends. The fix, in most cases, is not complicated. Call your bank. Ask how your accounts are currently titled. Ask whether they have any POD or TOD designations on file. If they do not, ask what is required to add one. At most institutions, it is a short form completed at a branch visit or sometimes by mail. The title of an account is not glamorous paperwork, but it is the paperwork that determines whether your family waits 3 days or 3 months to access funds when you are gone. Now we need to talk about the house. For most seniors over 65, the home is the most valuable single asset they own. It is also the asset most likely to be handled incorrectly or incompletely when it comes to estate planning. A will can say who you want to receive your home, but a will only controls assets that go through probate. If your home is titled in a way that bypasses probate, the will may not even come into the picture. And if your home is titled in a way that creates complications, the will alone cannot untangle them. The deed is the document that controls ownership of your property. It records whose name is on the home and how that ownership is held. Like bank accounts, real property can be titled in different ways: sole ownership, joint tenancy with right of survivorship, tenancy in common, community property in states that recognize it, or through a trust. In some states, there is also a special instrument called a transfer on death deed, sometimes called a beneficiary deed, that allows the property to pass directly to a named person when the owner dies, without going through probate. Here is the scenario that catches many families off guard. A married couple owns a home together in joint tenancy with right of survivorship. One spouse dies. The home passes automatically to the surviving spouse. No probate, no court proceeding. The surviving spouse then lives alone in that home for several more years. When that surviving spouse eventually passes away, the property is now held in sole ownership. And if their will names children as heirs, the house must go through probate before it can be transferred to them. This is a situation where a trust, a life estate arrangement, or a transfer on death deed, where that option is available in your state, might allow the home to pass without that second probate process. But those instruments must be set up while you are alive and mentally capable of signing legal documents. They cannot be created retroactively by a will. The timing matters. One important caution here, and please hear this clearly: do not make changes to a deed without proper legal guidance. Adding a child's name to a deed, removing a name, or restructuring how the property is held can have consequences for property tax exemptions, Medicaid eligibility calculations, potential gift tax obligations, and how capital gains taxes are calculated when the property is eventually sold. The intention behind the change may be entirely sound. The unintended result can be expensive. What you can do today, without any professional help, is pull a copy of your deed. In most counties, this is available through the county recorder's or assessor's office, and and many have put their records online where you can search for free. Look at whose names are on it and how the ownership is described. Then, if you have questions about what happens to that property when you pass away, bring that deed to an estate planning attorney and ask specifically about your options. The home is where your family carries the most emotional weight. Make sure the paperwork matches the intention. The first three forms we have discussed all deal with what happens after you die. This one deals with something that can happen while you are still very much alive, and it is the document that families in crisis discover they needed before they thought to ask for it. A power of attorney is a legal document that authorizes another person to act on your behalf in financial matters. That can mean signing documents, managing bank accounts, filing tax returns, selling property, dealing with insurance companies, or handling virtually any financial transaction, depending on how the power of attorney is written. There are different types, and the differences matter more than most people realize. A general power of attorney gives broad authority to another person, but in most states, it becomes inactive if you become incapacitated. Think about that for a moment. If you have a stroke, develop a serious illness, or are otherwise unable to manage your own affairs, the very moment you most need someone to act for you is the moment a general power of attorney stops working. A durable power of attorney is specifically designed to remain in effect even if you become incapacitated. This is the version most estate planning attorneys recommend for seniors, and for good reason. Without a durable power of attorney in place, if you lose the ability to manage your own finances, your family may need to petition the court to establish a formal guardianship or conservatorship on your behalf. That process can take months, cost significant legal fees, require ongoing court oversight, and sometimes create serious conflict among family members, all while your bills, accounts, mortgage payments, and financial needs continue without pause. Here's the mistake many seniors make. They have a power of attorney from 15 or 20 years ago, and they assume it is still valid and still functional. Some older documents contain expiration clauses that the person who signed them does not remember. Some banks and financial institutions have internal policies about how old a power of attorney can be before they ask for a new one. A document that is technically valid under state law may still be questioned or rejected by an institution for practical reasons. And equally important, if the person you named as your agent has died, moved away, lost your trust, or is no longer someone you would want making decisions on your behalf, their name is still on that form unless you have updated it. For adult children helping aging parents navigate this. If your parent does not yet have a durable power of attorney, or if the existing one has not been reviewed recently, having that conversation while your parent is healthy and capable of making the decision is enormously easier than trying to navigate the legal system in the middle of a medical crisis. A doctor's determination of incapacity and a court proceeding is a very different experience than a planned conversation with an attorney. A power of attorney needs to be drafted carefully and executed according to your state's requirements, typically requiring notarization and sometimes witnesses. This is not a form to take from a generic online template without fully understanding what authority it grants. Work with a licensed estate planning attorney in your state if at all possible. But the first step is simply this. Find out whether you have one, read who is named in it, and check when it was last reviewed. This is the one most families do not check until they are standing in a hospital hallway, asking a doctor to make a decision that no one prepared for. An advance directive, sometimes called a living will, a healthcare directive, or a durable power of attorney for healthcare, depending on your state, is a document that does two things. It outlines your wishes for medical treatment if you are unable to communicate them yourself, and it names a specific person to make healthcare decisions on your behalf in that situation. I want to separate this clearly from the financial power of attorney we just discussed. Your financial agent manages your money. Your healthcare agent, the person named in your advance directive, makes decisions about your medical treatment, your care, your interventions. These are two entirely separate documents with two entirely separate functions. They can name the same person, but they cannot be substituted for each other. Here is the concern. A significant number of seniors over 65 either do not have an advance directive at all, or have one that no longer reflects their current wishes or current relationships. Preferences about medical treatment can change over time. The person you named as your healthcare agent 15 years ago may have died, moved to another state, experienced a serious illness of their own, or simply is no longer the person you would trust with that kind of decision. There is also a form-specific issue worth understanding. Some states have very specific requirements about how an advance directive must be formatted, signed, and witnessed to be legally valid in that state. If you moved from one state to another after creating your directive, the document may not meet your new state's requirements. That does not automatically make it worthless, but it is worth verifying with a local attorney or your state's health department. Additionally, an advance directive that is sitting in a file at home, one that no one in your medical circle has ever seen, offers limited protection in an emergency. Most hospitals and healthcare providers have their own intake forms asking about advance directives. The document should ideally be in the hands of your named healthcare agent, shared with your primary care physician, and noted in your medical records. This is also where family dynamics become relevant. When there is no advance directive and a medical emergency occurs, family members members may have very different opinions about what the person would have wanted. That disagreement can create conflict at the worst possible moment, when decisions need to be made quickly and emotions are already overwhelming. A properly executed advance directive is one of the most considerate things a person can do for the family they love. To create or update one, you can speak with your primary care physician, an estate planning attorney, or, in many states, your local area agency on aging can point you toward free or low-cost resources. Some states have standard forms available through their health department websites. Whatever form you use, make sure it is properly executed according to your state's current requirements. Now, let us bring back the story we started with. She had found the outdated beneficiary designation on the retirement account. That discovery took several months and a considerable amount of legal effort to work through, and the outcome was not what her husband had intended. But as she continued going through his paperwork, which is something that almost every widow and widower eventually has to do, she found something else. There was a power of attorney in the file, dated 11 years earlier. It named her as his agent, but it also had an expiration clause, a provision she had never noticed, that had made it inactive 3 years before her husband died. During those 3 years, while her husband was in declining health, she had been signing documents on his behalf under the assumption that the power of attorney was still valid. Some of those transactions were questioned after his death. There was also an advance directive. It named her as his healthcare proxy, which was correct. But the document had been created in a different state, one they had lived in years before, and it did not fully conform to their current state's requirements for healthcare directives. The hospital had still honored her decisions, but only after a series of conversations and delays that added significant stress to an already devastating time. And there was no transfer on death deed on the house. The home had been jointly titled while they were both alive, but after it transferred to her at his death, she owned it alone, with no plan in place for what would happen to it when she eventually passed. She was not a careless person. She was not uninformed. She had a will. She had done many things right. What she did not have was a complete picture of how these 5 forms interacted with each other and with the will she had trusted. Her daughter helped her spend one afternoon, just one afternoon, reviewing each of the 5 forms we have discussed today. They updated the beneficiary designations on her remaining accounts. They confirmed the title on her bank accounts and added payable on death designations. They pulled her deed and asked an attorney about a transfer on death deed available in their state. They had a new durable power of attorney prepared, and they updated her advance directive to meet current state requirements and gave a copy to her physician. That one afternoon did not fix everything instantly, but it gave her family a clear picture. And it meant that when she eventually passes away, her wishes will be reflected not just in her will, but in the system of forms that the law actually follows first. Here is what I want you to take from this video. Not a list of things to panic about, but a practical starting point. This week, pull out or locate these 5 things. 1. Your most recent retirement account, IRA, or life insurance policy statement. Call the institution and ask what beneficiary designation they have on file. Write it down. 2. The most recent statement for your primary bank account or accounts. Call your bank and ask how the accounts are titled and whether there are any payable on death designations on record. 3. A copy of your property deed. If you own your home, you can usually find this through your county recorder or assessor's website. Look at how the property is titled and whose names appear. 4. Any power of attorney document you have previously signed. Check when it was created, who is named, whether it is described as durable, and whether there are any expiration provisions. 5. Any advance directive, living will, or healthcare proxy document you have. Check who is named, what state it was created in, and whether it reflects your current wishes. You do not need to change all of these today. You may find that everything is exactly as it should be, but you cannot know that until you look. If you find something that does not look right, a name that should not be there, a document that seems outdated, a form you cannot locate at all, that is worth a conversation with an estate planning attorney, a financial advisor, or in the case of healthcare directives, your primary care physician. Rules and requirements vary by state, and your specific situation, your family structure, your assets, your health, matters for how these forms should be set up. This video is not a substitute for professional guidance tailored to your circumstances. What it is meant to do is give you enough understanding to have that conversation with confidence. A will is important, but a will works within a system, and that system has its own set of rules, its own hierarchy of documents, and its own order of operations. Beneficiary designations move money outside of probate. They follow the form, not the will. Account titles determine whether a bank account transfers instantly or gets tied up in a legal process. A deed controls what happens to your home, and a will alone may not be enough to direct it efficiently. A durable power of attorney protects your financial life while you are still living if you become unable to manage it yourself. An advance directive protects your medical wishes and takes the weight of impossible decisions off the people you love. 5 forms, not one of them exotic, not one of them requiring enormous wealth or a complicated estate to be relevant. Potentially all 5 of them sitting somewhere in your life right now, some of them outdated, some of them never set up. This is not about fear. It is about control. The people who are most protected are not necessarily the people who have the most money or the best attorneys. They are the people who took the time to check before a crisis made checking impossible. If this gave you something useful, share it with someone in your family who handles the paperwork, a spouse, an adult child, a sibling. This is not easy information to bring up, but it is far easier to bring up today than it will be later. If you want to go deeper on any one of these, how beneficiary designations work on IRS specifically, what a transfer on death deed looks like, what questions to ask an estate attorney before you make any changes, leave a comment below. Tell me which form you want to understand better, and I will make sure we cover it. And before you change anything based on what you have heard here, review it with a qualified legal or financial professional in your state. The goal is not to act fast. The goal is to act right. Take care of the paperwork today so your family can take care of each other later.